Please be seated. Welcome everyone to the First Court of Appeals. We have two cases on the docket this afternoon. The first is case number 01-22-00827 CV, Jason Alexander versus the Woodlands Land Development Company, the Howard Hughes Corporation, LGA Engineering, and James R. Bowles. The second case is 01-23-00004 CV, Hilary Rochelle versus Travis Services Group and Travis Company DBA PUROCLEAN Services. Let's see here. Let's have our appearances, if you would.
Kelsey White for the appellants.
Thank you.
Jennifer Forrest for Woodlands Land Development Company and its parent company, Howard Hughes.
Todd Collins for LGA Engineering and James Bowles.
Terrific, thank you. Okay, now I understand that the appellant has reserved time for rebuttal.
Yes, sir.
Okay, and the appellee is splitting time. Is that right, Ms. Coy?
Yes, Your Honor, 17 minutes.
And
I'll be arguing 3 minutes later.
Correct. Okay. Alrighty. I think we are ready to proceed.
Thank you, and may it please the court. I always forget how close this is and how low it is until I stand up at it.
Are we having issues with the microphones? Can everybody hear?
I feel like I can't hear very well, but it might be mine.
Could be my distance from it.
Maybe. It's all right. Go ahead.
We can hear you.
I will try to speak up. May it please the court. The issue presented in this case is straightforward, and the court can resolve it by applying ordinary negligence principles. That issue is whether a defendant who has an affirmative duty to act, like the Woodlands did here, can simply discharge that duty by outsourcing it to and relying on a third party like PATE. The answer to that question is no, and I'd like to take a few minutes and explain why. Here, the Woodlands expressly recognize that to avoid potential flooding in the Creekside Timber and Development, it had adopted a policy of requiring the plaintiff's homes be constructed on slabs at least a half a foot, at least 6 inches above the flood of record. When I refer to that, I'm referring to the October 1994 flood, which was greater than a 500-year flood. The Woodlands imposed that minimum slab elevation policy on the builders in Tiburon. But what happened after that? The Woodlands did not implement its own mandatory minimum slab elevation policy. The builders did not build the plaintiff's homes 6 inches above the minimum slab policy of record. And as a result, more than 400 plaintiff's homes flooded. What does Woodlands argue to avoid its expressly recognized duty? A few things. First,
may I stop you there?
Sure.
Since you say expressly recognized duty, can you please go through the duty issue and explain from where you get a duty by the developer in this case?
Sure. So they argue first, we argue that their own unimplemented policy is the duty. They say it's not a policy, it's merely a recommendation. And so that's the first place we join issue, because I want to refer the court to their documents. The Woodlands' own document states, and I quote, "We developed a policy, not a recommendation, a policy to designate the minimum slab elevations to be a half a foot above the flood of record, the 1994 flood." And that's Appendix 6.002. And the documents also reveal that it wasn't a recommendation, it was a requirement that the Woodlands imposed on its builders in Tiburon. When I refer to that, I'm referring to the development criteria, Section 16, Appendix at 3.0001. The introduction says, and I quote, "The builder shall develop the property and construct homes in accordance with the contract and development criteria." Section 7 of that same document says the following establishes absolute minimum elevations.
So can I take you a step back and separating out the negligence claim from the negligent undertaking claim. So would the duty then arise, is the duty different from where it arises if we're talking about the negligence claim versus the negligent undertaking claim? Because what you're talking about now to me sounds more like negligent undertaking because it's things that they affirmatively did and took on themselves, which I think when I'm thinking about duty under a negligence cause of action, I'm thinking about where does the law impose a duty on someone.
I'm happy to do that, and they so closely overlap here, but I think that the court never needs to get to the undertaking claim, and I want to explain why. Under the ordinary duty principles of Greater Houston Transportation Authority versus Phillips, the court can find a duty on this record without getting to the assumption or the undertaking. We do not agree.
Mr. Moore, I'm sorry. I'm sorry, go
No,
ahead.
go ahead. No, I was just saying, glad you're asking.
Was that argument though about Phillips presented to the trial court at any point?
The ordinary duty analysis was presented to the trial court. And we've maintained, I saw in the brief, they say we've abandoned their negligence claim. We didn't abandon the negligence claim. We focused on the motion for new trial and the undertaking issue, but both are pleaded in a fair notice state, and it's the courts, they have the burden of, if we didn't file a response to the traditional motion for summary judgment on the duty issue.
But what if your response doesn't address any of the factors enumerated in Phillips?
The same answer. I can get to the undertaking, but under a traditional summary judgment standard, if they say we do not owe a duty as a matter of law, they have to demonstrate no duty even if we didn't file a response. I think the response adequately sets it forth, but under just traditional summary judgment applications and standards, they have the burden if we don't file a response. So the court should be able to look only to their motion for summary judgment to demonstrate that they had no duty.
But if we're going to back up a little bit and hypothetically take issue with whether the case law, like Parkway, for example, establishes a duty here, then when they argue that in their summary judgment motion, no duty, the law, that Parkway doesn't say that, there's no case that says that, and then you guys respond and argue, yes, Parkway does say that, yes, you do have a duty, but don't necessarily get into, even if we don't have a duty, here's how we would ask you to find a duty. I don't know that I see that argument was made, and I guess I think that's where maybe, I don't want to speak for us, but where a little confusion is in that if we are looking to decide this case and potentially have to affirm on any ground that the trial court might have been ruling on, what do we do with all that?
Two parts. One, again, you can't affirm on the ground that they haven't conclusively established they had no duty as a matter of law. And so I go back to, without looking at our response, they have the burden of conclusively establishing no legal duty. We talked about Parkway, and I want to talk about that case. They said Parkway doesn't stand for the proposition that there is a duty. Parkway acknowledges there is a general duty in a flooding case like this, and all they said in that case was, we are not going to expand a common law duty of implied good faith and fair dealing on this record because the plaintiff has adequate damages and negligence. So I think under Parkway, which is what we argued in the trial court, we survive under a Parkway versus Woodruff analysis under general negligence principles.
But wasn't negligence not really at issue in the appeal? Wasn't it more about the DTPA claims?
They affirmed mostly, except they deleted the middle language damages. They talked about whether they were going to expand a cause of action, an implied cause of action, and they said we don't have to because negligence. I think the easiest way to think of this case with regard to Parkway versus Woodruff is, they said Parkway doesn't get us there on duty because in that case they did something, they built a wall. But I don't think they would dispute that in Parkway, if the developer had said, we are going to build a wall, and they never did, they wouldn't be arguing that they didn't have a duty under those circumstances. That is like this case. They affirmatively implemented a policy, which also takes us to the undertaking. They're so interrelated. They affirmatively, and this was explicitly briefed in the trial court, undertook a duty to impose a 6-inch minimum slab requirement on everyone who was going to build in Tiburon. And I want to point the court to one of their cases because I think it's sort of the best exemplar of why summary judgment was improper here. If the court looks at Texas Home Management versus Peavy, which is cited in their brief, the court analyzed the duty and said that with regard to determining whether there's a duty, the two prongs are, is the danger known, and does the party have the ability to control the conduct of a third party? Here the danger was not just foreseeable, it was foreseen. They did their own, they undertook to model their own. They had high water modeling. They created a high water map, so they had actual knowledge of what the flood level map should be. So they had actual knowledge that satisfies the first, and they had control. If the court looks at the criteria development, they have said that the builders shall perform an absolute duty. Whether this is a negligence claim or an undertaking, it is a directive to somebody that they have to perform 6 inches above the minimum slab elevations. Not 6 inches above what Pate said. And this bleeds over into the undertaking argument, Justice Guetta, that they're saying our undertaking was only to outsource it to Pate and then to implement the minimum slab requirements based on Pate's modeling. But if you look at the documents, that's not what it says. Their undertaking is to build six inches at least above the flood of record. Not above the flood of record according to what Pate says. So it satisfies the duty component in an ordinary duty analysis, and it satisfies the duty component of a negligent undertaking claim because they explicitly did something and mandated that somebody perform it. In the Peavy court, this is a Supreme Court case where they reversed the summary judgment, and this is what they said, and this takes me back to who has the burden. The Supreme Court said in Peavy that the defendant, quote, failed to establish it should not have reasonably recognized the danger, and it failed to establish as a matter of law that it had no duty to reasonably exercise its right to control. Here, they recognized the danger and implemented a policy to address it. And they explicitly retained control over the builder. You shall perform in this manner. We reserve the right to inspect. It's in the development criteria. And they required that the builders obtain a survey where the survey demonstrated that the homeowners are going to be built to the minimum, and to provide that survey to the builder. So under their own case, Peavy, we have satisfied all of the criteria to defeat summary judgment because they didn't conclusively establish what the defendant didn't conclusively establish in Peavy that resulted in a reversal and a remand.
Mr. Moore, assume that we agree with you to a certain point, but that Parkway doesn't get us there in terms of duty, and we're forced to resort to Phillips, and we agree with you that that was sufficiently presented to the trial court. What do we do with Mendez in terms of the Supreme Court being unwilling to recognize new duties, to allow for the creation of new duties?
I don't believe this is the creation of a new duty. I think Parkway didn't say there's no duty in this context, and if you look at all their duty cases like Mendez, and I believe the Mendez is the drug testing case.
It is.
And Mendez is the case where they said, we're not going to impose a duty because the privity or the duty was between the employer and the contract for the drug screener was between the employer and the screener. The employee was just coincidental. So they said, we're not going to impose a duty to the employee, and they talked about the factors from Phillips, which was there's social utility in making sure people are drug-free. paraphrasing, we're not going to wade off into that in these circumstances where the obligation ran between the drug screener and the employer because of the social utility of it. That takes me, if we apply that reasoning in the Mendez case to these facts, we agree that there's social utility in development, but the burden of requiring someone like the Woodlands to exercise reasonable care with regard to the implementation of a mandatory policy is de minimis. And the best way to say that is literally all they had to do here, in addition to what they already have done, is to follow their own contract language and to require the builder to do what the contract documents required. Give us the survey, build it within 6 inches of X, or to check Pate's modeling. There's not much burden here that defeats the social utility like it did in the Mendez case. So that's why I think Mendez is so different.
In the Mendez case, the dissent had some pretty compelling arguments around what was happening in other states with regard to that topic, and in states that did recognize a duty on the part of the drug testing company to basically behave reasonably in the way that they handled the materials. Is there, I mean, it's not in your brief, but is there anything that you would point us to, or any cases other than Parkway that, because you said you don't think it's a new duty, so what else would we look at?
Well, I think this court's case in Texas Women's by Justice Jennings is similar. I think the Helbig case is similar. I think that those are undertaking cases, but with regard to out of state, they dropped a footnote and they've talked about a couple of cases from out of state. I looked at the case, the Marnetti case, and the other case that they cited in their footnote. There was no evidence in either of those things to give rise to a duty. There was no evidence that the developer knew in those cases that the property was flooding. And there was certainly no evidence that the developer not only knew about it, they had created a company policy to require people to perform in a minimum manner. So to the extent, those are the only two I'm aware of, are the ones that they cited, and they're wholly distinguishable from this case because neither of them have the predicate facts that give rise to a duty that this case does.
Does it make any difference that they were already obligated to build 6 inches above the 100-year flood mark, water line, whatever the terminology is, and then I think the argument is that they were, trying to go above that by using the 500-year, the 94 flood. Does it make any difference?
I think I appreciate your question, and the answer to that is no. That they performed the minimum regulations set forth by the Harris County Flood Control District or a governmental authority does not discharge their duty. The duty that they explicitly adopted was, we will be 6 inches above the 94 flood, which was 6 inches above a 500-year flood. The 94 flood was a 500-year flood. So for them to say, well, we've discharged our duty because we complied with the governmental regulations, and we cited the Golden Villa nursing case in our brief that says compliance with the governmental regulation is not a discharge or a duty. It doesn't relieve you of a different burden like they have here.
Okay, thank you.
I'm out of time. If the court has any more questions, I'm happy to answer them.
May it please the court. The Woodlands Land Development Company developed large tracts of lands of the Woodlands, which it then sold as sets of empty lots to builders, who then designed homes, planned homes, permitted the homes, built the homes, and then sold the homes to plaintiff homeowners with whom my clients have no relationship, as the record makes clear at CR 2860, which directs the court to every appellant deposition. Some plaintiffs flooded in Harvey, and plaintiffs sued my clients alleging negligence and negligent undertaking claims. After 4 years of litigation, including the deposition of every appellant, Judge Palmer granted summary judgment on both negligence and negligent undertaking on 3 independent grounds: duty, breach, and causation. This court need only agree with a single one of those to affirm, but all 3 are correct. I'll start by briefly touching on negligence duty, then I'll address their negligent undertaking claim, and then I'll turn to causation. Starting with negligence duty, there is no basis for this court to conclude that there should be a duty here under current Supreme Court law. First, this court need look no further than Elephant and Mendez. Parkway did not create a duty in one sentence in a case that precisely said it was not addressing negligence. As they concede in page 9 of their reply brief, there is no existing duty. So the question becomes, under the Phillips factors, should this court create a duty, which is something that the Supreme Court has cautioned the court to be cautious about doing, and the court should not do so under Mendez and Elephant, in particular in light of the fact that there's a comprehensive regulatory backdrop here. You have FEMA and Harris County that have already said, look, we're going to set slab heights, and their slab heights are far lower than any minimum we set here. And in light of the fact that we have no relationship with the plaintiffs here on this undisputed record. Turning to negligent undertaking, because the claims often bleed together, this claim is a claim that exists in the even rarer instance where the law doesn't create a duty, but the person in my client's situation takes affirmative action necessary for the protection of the plaintiff, on which the plaintiff relies, and to the plaintiff's detriment. And there are 3 independent reasons the court should conclude that there's no negligent undertaking here and affirm below. 1, they can't create a fact issue on reliance, which is a necessary element of their claim. 2, under controlling Texas law, the failure to follow a policy cannot support a claim of negligent undertaking. And 3, they can't create a fact issue on duty or scope, but they need both to win here. And starting with reliance, Your Honors, again, this is an essential element of their claim. The record directly refutes reliance in 2 places. First, CR 2860. This is, again, a page, it excerpts one plaintiff's deposition and then it points the court to an appendix with all appellants' depositions. And what do appellants all admit? That 1, they had no oral communications with my client. 2, they had no written communications with my client. And 3, my clients did not influence them when they were buying their homes. So not only did they not rely on my clients didn't influence them in any way when they were buying their homes. This is their testimony under oath. I next point the court to Appendix 3. Appendix 3 is the home buyer information guide. It was on builder letterhead and it communicated information we wanted prospective home buyers to know. And what did this tell prospective home buyers? 1, we have no involvement in the building of your homes. 2, we make no representations or warranties to you. And 3, by the way, you might be in a flood zone. There was once a bad storm here, and we urge you to talk with your builders. They can't show reliance as a matter of law. And to raise a fact issue in their briefing, they point you to one email that appears in Appendix 6. And that is no evidence of mere speculation. That's an email between people from my company, people from the Woodlands, years later, where somebody says, hey, at a builder meeting, there was a question about what the flood of record is and when that happened. And then somebody responds from my company, oh, flood of record's a really confusing topic. Here's some background, and we're going to think about how we would communicate that with customers. Well, first, our customers were the builders. But even if you put that aside, that's no evidence that anything was ever communicated, much less what was communicated. And even if something was communicated, it's no evidence that they relied on it, especially in light of their sworn testimony that they didn't. That alone is enough for you to rule in our favor and affirm on negligent undertaking.
I have a question going back to a little bit of my discussion with Mr. Moore regarding Parkway and Phillips. So, obviously your argument is there's no duty as a matter of law. Is there, what would be, what is the argument? I mean, I've read your brief, but what specifically, as far as the social utility aspect under Phillips?
Yes, sir.
And just sort of the overarching, law feeling that that a person an entity developing a neighborhood. This may or may not be the law, but that there is certainly a gut reaction to, why wouldn't the company developing a neighborhood ultimately owe at least some slight
duty or responsibility to the ultimate folks who are, you know, buying and living there. Can you walk me through that under, assuming that duty doesn't exist now, how we would write this opinion to say that a new duty shouldn't be created?
Absolutely, Your Honor. If you look at Mendez and Elephant and the Mission Petroleum case, when the court looks at the social utility, often the court also looks at to what extent other branches of government have already addressed the social utility. Here, there's immense value in the development of homes and keeping home prices low, and the balance of what burdens, if you put a burden on us that increases our costs and raises everything. But here, what you have is an instance where other branches of government, again, FEMA and Harris County, have addressed this precise question. They've looked at all of the costs and benefits and balancing, and they've said, we're setting slab heights here. My client came in and set slab heights here, and we didn't set slab heights. We set minimums that, of course, could have been exceeded, but far above the regulatory framework. And the regulatory framework is a crucial part of the social utility analysis, because the question then is, should this court come substitute its own view of the social utility when the political branches of government have already addressed this and have already made a determination? And do you want to come in and say, we're going to require more of these companies?
Ms. Coy, isn't the fact that the regulatory requirement was so low and the developer said, oh no, we're going to exceed that, evidence that the regulatory framework was insufficient?
Well, they have no evidence here that the regulatory framework was insufficient. There's no evidence that we attempted to exceed it because it was insufficient. And I'd like to take the court to the broader Texas framework on the law for making a policy that's better than the law. And Texas, as a matter of public policy, simply does not punish companies for doing better than the law requires. And you can see that in 4 different pieces of precedent that are helpful here. One is the
But
Torres
isn't their
case.
argument that they didn't do better than the law requires?
They don't dispute that we did better than the law requires. They just say we should have done even better. They say we made a policy and we didn't meet it. But certainly, even so, our minimums that we set were far above the regulatory requirements. The regulatory requirements were at the 100-year flood. They're saying ours were not as high as they wanted based on this policy we created. And Texas law doesn't allow for that sort of claim. In 2022 en banc, this court in Torres said you cannot premise a negligent undertaking claim on the failure to follow a policy. I'll also point the court to the Entex v. Gonzalez case from 2002 out of the 14th Court of Appeals that tells the court that an internal policy cannot create a duty for a negligent undertaking. It's your own policy. There's the FFE case we cited in our brief from the Texas Supreme Court in 2004 that says standard of care can't be based on something you self-impose that's greater than the law. And I'll also point you finally to the Sprush case out of the Texas Supreme Court that says if you make a plan, unless you've communicated it to the plaintiffs, which here there's no evidence of, it can't support a negligent undertaking claim. So when you look at all of these different lines of precedent in Texas, what they come back to is that when you as a company aspire to do better than the law, you're not going to be punished unless there's something in the record that says it was clear that you had to do higher than X and you didn't do that, or something to that effect. But I'd like to take you to where they try to make a dispute here on the facts, because they have to create a fact dispute on duty and breach here, and they can't do either. And I'll walk you through why. First, starting with the duty. The duty is defined by the scope of the duty is defined by what we do, not something we might have thought about doing, planned to do, budgeted to do, started and abandoned, but what we did. And here the record's undisputed. What we did is we set a policy. He says I dispute that, I don't. We set a policy of saying we're going to make minimum slab height, flood of record plus 6 inches. That's what we're going to do, far above regulations. And how are we going to go about doing that? Well, there's only one way to do that, and that's modeling. We're talking about completely undeveloped land 13 years after a storm. You can't go look these numbers up in a book or measure them. So we hired who their own experts say were well-respected experts who use state-of-the-art modeling. Those experts gave us numbers, and we, in turn, added 6 inches and sent out those numbers. So when you look at the scope of what we tried to do, we didn't try to do anything else. Now, they try to make a fact dispute with you about this data from 1994. They say, okay, they had data from 1994. We don't dispute that. In a different county, Montgomery County, In 1994, right after the flood, we recorded some high water marks, and the map that they point to shows you they were recorded in 1994 contemporaneously. Well, there's no evidence that in any way links that recording of data in 1994 from Montgomery County to the effort here to create a policy for this neighborhood in Harris County of flooded record plus 6 inches. There's simply, if you're looking at duty or there's simply nothing in the evidence that connects in any way that data. We never undertook to do anything with that data, and you cannot premise a negligent undertaking claim on an omission. But their argument is that we didn't check our experts. That's really what their argument boils down to, is that we didn't check our experts. But whether you want to view this as duty or breach, we simply had no obligation to check our experts. Again, it's an alleged omission, and there's no evidence that we ever undertook to check our experts. And then if you're thinking about the breach context, just think about the ramifications here. Even if you assume everything they argue, the question is, should the court find a fact dispute and say that the standard of care could require you, non-experts, hiring well-respected state-of-the-art experts to overrule them? This is not a negligent hiring claim. There are lots of avenues they could have pursued. This is not a negligent supervision claim. They didn't sue Pate. They sued us, and they say our negligence is that we didn't override our experts based on 3 data points, not even in this area, miles away. Out of 420 data points, they say we should have overridden our experts. Well, can you imagine the ramifications if this court were to hold that the standard of care would require you to double check and override your experts as non-experts? Nobody could ever rely on experts anymore. And that's just, so they pointed you to no law and no evidence to support that.
Can I ask a question going back to just, that I'm kind of hung up on, just the duty generally?
Yes.
So looking at Parkway, I understand that the negligence claim was not, brought up in the appeal, but certainly the Texas Supreme Court, I guess if it thought that a developer should not have any duty in a negligence claim, it could have said that, if that's what it thought. Do you have a response to that or thoughts about that?
Yes, Your Honor. It would have been purely advisory there for the court to comment in any way on negligence. That was a case where in the first sentence the court said negligence was not challenged on appeal. It was a case asking about an implied warranty, and the court has a whole long reasoning as to why they're not going to find an implied warranty. And there's one sentence at the very end of that discussion that says, in addition, the people seeking to impose implied warranty haven't met their burden of showing negligence damages wouldn't be enough anyway. The Elephant Texas Supreme Court explained that the court should not create duties lightly, and that the creation of a duty is a big deal. You have to consider the broader context. You're affecting all these different actors. It just can't be that in a case that wasn't addressing negligence, in a throwaway final sentence that says they didn't meet their burden, not that we agree, but just they didn't meet their burden, that somehow created an entire new duty for developers, especially not one that's applicable here. I mean, they don't give any of the facts are completely distinct there. There, the developer made a wall that diverted water directly to the plaintiff's property, exactly as the plaintiffs predicted would happen. I mean, it's just not analogous. And taking the
but
court,
if they going back to that point that they don't want to create duties lightly, and they take that all into consideration, if the case before them has negligence findings, and even I understand what you're saying, that it would be advisory because it wasn't raised by the developer in the appeal, but if they felt strongly that there should not be a duty, they could have said it in that case and not allowed a judgment against a developer that was based on a duty that now you say is does not exist.
I'm not sure, Your Honor, that they could have said that when it wasn't raised. The party did not appeal negligence, so I don't know how the court could have said we're going to reverse on negligence. It just wasn't before them. And again, saying the other party hasn't met their burden doesn't mean that they agree. But in any event, when you look at, when Parkway doesn't, in my view, create a duty, and when you look at the Phillips factors, foreseeability, I point you to the Elephant case. It's completely analogous. Any risk here that they're claiming, to the extent it was foreseeable, was open and obvious. and nothing that my client did increase the risk in any way at all. If we hadn't acted, the minimums, with our minimums, the default was lower, and it wasn't foreseeable in any way on this record that the builders would not build higher if they needed to. This is the opposite of their Holly case. In Holly, Columbia River v. Holly, there was evidence that doctors weren't getting pathology reports. So hospital makes a plan to give you pathology reports. They fail, it's foreseeable. You won't, that the doctors weren't going to get them. Here, there's no evidence that these well-respected builders wouldn't do what they needed to do when built. They're the ones on the ground. And an elephant said to the court, looking at foreseeability, yes, the insurance company instructed the plaintiff that you should take pictures of the accident scene. But looking at that, the court said it wasn't foreseeable that the plaintiff would do that if it was dangerous to actually do it on the ground. Well, we had no control over what the builders ultimately did. We sent them minimums, but of course they could have built higher. There's no evidence otherwise. And here, just as an elephant, it's not foreseeable that when they were on the ground and doing the permitting and actually building the homes and looking at these sites, that they wouldn't have built higher if they needed to build higher anyway, especially because the risk was equally obvious to them and to plaintiffs. Your Honors, there is no basis here to create a new duty. There's no existing duty, and the court shouldn't strain to find a negligent undertaking claim. Plaintiff's recourse is not with us. Their recourse is with the builders, with whom they have existing arbitration, or with Pate, whom they elected not to sue. If you don't have any questions, thank you, Your Honor. Thank you.
Good afternoon. I represent LJA and James Bowles, and just wanted to say that we concur with her arguments. We have joined in the saying we signed the motions for summary judgment. We have even a less burden than they do on the standard of care, based upon we've no privity at all with any of the plaintiffs, and our client was the Woodlands. We were provided information from Pate Engineering, which we relied on, which is acceptable under the Engineering Act in Texas. There's been no evidence whatsoever that we were failed on the duty to do that. It's just the negligent undertaking, which I think she's addressed completely. Just wanted the court to know that we're one step removed from the Woodlands. And since I wasn't mentioned at all in the original argument, and I haven't been mentioned much in any of the briefing, I would just ask the court for questions if you have some. I'll reserve the rest of my time for Jennifer if you see fit.
Thank you.
Thank you.
Thank you, Mr. Mullins. Mr. Moore?
Thank you. I'm just going to make one quick point about the engineers, and that is them signing off on the developers. MSJ did not address any of the claims against the engineers. All of the developers' motions grounds relate only to the developers. They're asking the court to convert a traditional motion for summary judgment into no evidence motion for summary judgment on this side, and there's no procedural basis to do that. So I'm going to step into the developers, and I'm going to try to go backwards from the notes that I took. And I want to start with the statement that they had no control, which is just contrary to the summary judgment record. The development criteria, they retain contractual control. It has shall in it, it has absolute in it, it has requirement in it. That language is mandatory, it's not permissive, it's not a recommendation. And they contractually retain the right to require the builders to build 6 inches above the flood of record, not the flood of record for Pate. So that's the first thing. Secondly, I'm not asking the court to endorse them overriding an expert. What I'm asking the court to do is to acknowledge the duty that they have. Their explicit duty is 6 inches above the minimum of the flood of record. The summary judgment record shows that they paid Pate $9,600 to perform computer modeling. not actual high water marks. And they're trying to hide behind that $9,600 mistake by adding language to their explicit duty, as modeled by pay, as modeled by pay, as modeled by pay. That shows up nowhere in this summary judgment record. They also said two things that are internally inconsistent, not possible. There's no evidence it was foreseeable, and simultaneously it was equally foreseeable to the homeowners and to the developer. It cannot be the same thing. It was foreseeable, they actually foresaw it. And the elephant case is everything this case isn't. It's where an insured gets out on the side of the road and starts taking pictures and gets struck. And the Supreme Court said, we are not going to impose a duty in that case because it was equally foreseeable to the insured who's out on the side of the road. You don't have to be taking pictures, they said, to get hit. You just have to be up by the side of the road to get hit by a car. So the insured, it was more foreseeable to the insured than the insurer in elephant. And that's why they declined to impose a duty. Here, it was more foreseeable to the developer. How do we know it? Because they undertook their own data collection. They created a high water mark map. They used that to create a policy. And one really important thing is that they've cited 4 cases that she referred to about an internal policy cannot create a duty. That is not a correct statement of law. Those 4 cases say an internal policy does not establish the standard of care. So if we just talk about duty, and we don't conflate duty with the standard of care and breach and evidence of breach, and we isolate duty, there's a duty in this case, and undertaking a policy and then negligently implementing it does provide a basis for a duty, and the court doesn't have to look any further than the Texas Women's University versus the Methodist case.
This is a, may sound like a simplistic question, but how specifically, what would that sentence say in an opinion? Therefore, we recognize a duty, the duty was...
I think that you would use the PV case. In the general negligence case, generally Texas recognizes that a party has to act reasonably not to harm another party if the risk is reasonably foreseeable or can be anticipated. It is not disputed here that the developer anticipated the risk and created a policy to address it. So I don't think the court has to say we're creating a duty. I think standing on ordinary duty principles, the court can impose a duty in a case like this. Did that answer your question? I'm going to move to the negligent undertaking very quickly because there's an allegation that there's no reliance. We cited the Ernst & Young case about a reason to expect, and if you look at the appendix site, the email, they are discussing internally that customers are asking about flood and flooding. At the summary judgment stage, what reasonable inference can the court draw from a Woodlands development document signed by its president that says this is the policy that we've implemented and this is what you communicate to customers like the plaintiffs? And so she referred to one plaintiff's depot. That doesn't eliminate reliance as a matter of law for 420 people who suffered a catastrophic flooding event. If the court doesn't have any more questions, I see them out of time.
All right, thank you for your argument.
Thank you.
All right, thank you to counsel for arguments and briefing in this case. The appeals are submitted and this case is adjourned. We are going to take a brief break to allow people to cycle in and out, and we will return for the second case.
All right.
That's what I was reached out to. How old are you? Oh, so you're thick in it. That's the best. We went out shooting and cutting subject. Our daughter just finished her birthday. That's at the school. She's got to forever. She's moving to a different school for 6th grade next year. And all the schools so fun.
Definitely, I remember that.
Yes, yes, those are hard
Yeah.
days, but they're so sweet. And they really want you then, and so they go, they let us in here and spend. Last night I said to the kids, do you want to hear mommy's argument about this? And they were like, no. I said to my daughter, listen, and she said, I kind of get it. Oh my God. My son was like, I have no idea what you're talking about. Really, but no.
Take care.
It's gonna be top to bottom first.
Yeah, they're both legends.
All right. Hearing, the Court of Appeals for the purposes of protection is now in session, pursuant to adjournment. God and the Constitution and the Honorable Court.
Please be seated. All right, we are on to our second case, 01-23-0004 CB, Rochelle versus Travis Services Group et al. May we have announcements, please?
Yes, Your Honor. Michael Davis, my co-counsel, HUGHES, on behalf of the appellant for Rochelle.
Thank you. Okay, thank you.
Ryan Pitts and my colleague Karen Strench on behalf of Travis Services Group, Inc. and Travis Company, DBA PUROCLEAN.
Thank you. And you have reserved time for rebuttal, appellants?
Yes, Your Honor, reserved 5 minutes.
Okay, perfect. All right, we are ready to begin.
May it please the Court. My name is Michael Davis, and I represent the appellant and cross-appellee, Ms. HILARY Rochelle. As this Court is aware, there are a number of issues raised on appeal, and there's also a cross-appeal. But during my limited time before the Court, I want to focus on the question of homestead exemption, because I believe answering that question will address numerous issues raised by the appellant and the cross-appellant in this case. The Texas Constitution affords strong protections to the homestead. If a contractor places a lien on the homestead, there are certain requirements that have to be met. One of those requirements is that the contract has to be signed at the office of an attorney or a third-party lender. It's undisputed that that didn't happen in this case. The contract was signed at Ms. Rochelle's home, And the contract that was drafted by the appellees states that Ms. Rochelle was residing in the home at the time the contract was executed. The lien affidavit that was drafted and filed by the appellees states that Ms. Rochelle was residing in the home at the time the lien was filed. The appellee's plaintiff's original petition states that Ms. Rochelle was residing at the home at the time the petition was filed. So it seems that it's undisputed that at least at some point, this was Ms. Rochelle's homestead.
May I ask you a question about that? Is there anything in the record that would function as a stipulation or a concession that Ms. Rochelle was using that property as her homestead?
Nothing in the record that would stipulate that she was using it as a homestead, as that term is legally defined. But we believe that the contract which says that she was residing there, and the lien affidavit that says that she was residing there, and also their own witnesses' testimony that she was residing there at the time the contract was signed, is sufficient to at least establish the homestead exemption, shifting that burden to the appellants. But if that wasn't enough, Ms. Rochelle also testified that she had lived in that home since 1989. She had raised 3 children there, and she had even raised her stepchildren there, and lived there throughout the time that the Travis services were working on the home. Even at one point, she asked if she could live in one part of the home while the contractors worked on the other side.
So the relevant time frame that we're looking at as to whether this is her homestead, it's the time that the contract was entered into, is that correct?
Yes, Your Honor, because if a contractor wants to engage in a contract and possibly put a lien on someone's home, from the very get-go, they have to take that person and they have to go to an attorney's office or a third-party lender's office, and they have to sign the contract there. So from the very beginning, the contractor is put on notice that, hey, if I want to put a lien on this homestead, I got to meet certain constitutional requirements. And it's undisputed that the contract was signed at Ms. Rochelle's home while she was residing there, and she had lived there since 1989. And so at that point, the burden is on the appellees to plead and prove abandonment. But they did not plead abandonment in their petition. In fact, I don't think they even argue abandonment until they get to their response to Ms. Rochelle's motion to modify the judgment on page 615 of the record. This abandonment argument, we believe pretty strongly, is really a post-trial argument that they're making at this point. There really wasn't a big dispute over abandonment in the court below. There was at times some directed verdict, but not clear proof of abandonment, or undeniably clear proof of abandonment, as this court has held in Hankins versus Harris. That's required. The Constitution affords such strong protections for the homestead that this court held in Hankins versus Harris, as well as Solomon versus Lassay, that any doubt is construed in favor of the homestead. And once established, it is that person's homestead until abandonment, alienation, or death.
I want to go back to the question of how it was or if it was conclusively established in the trial court that that was her homestead, because there wasn't a jury question on it, correct?
No, Your Honor.
And so, can you just literally walk me through which evidence conclusively established it's her homestead? And I'll admit that I struggled a little bit to find anything in the case law that was directly on point. It seemed like a lot of the cases dealt with situations where there were other properties that the person owned and there was some sort of dispute over which one was the homestead. And so it feels a little bit like maybe there was an assumption that this was the homestead because it was the only home she lived in, but I don't read the case law to say that we can just assume that because she called it her home, it was also her homestead. So what else points to that and supports it from the conclusively established standard?
So there was no argument in the court below that Ms. Rochelle had claimed any other home as a homestead. That is something that, as you just mentioned, a lot of courts will look to. But the evidence that we put forth to show that she conclusively established as her homestead is, at first, their own evidence of that she was residing there at the time of the contract, the lien, at the time their petition was filed, their own witnesses' testimony, who discussed that she was living in the home, and then our witness, Ms. Rochelle, testifies that she had lived there since 1989. So from 89 until the time the contract was signed, Ms. Rochelle lived in that home and raised several children, including her sister's children, in that home. And so that's the evidence that we believe conclusively proves that there was a homestead. We also would say that that evidence is undisputed. And the Texas Supreme Court has held that you don't submit an undisputed question of fact to the jury. The burden was on, once we established and put forth evidence of homestead, and it was undisputed that she was living in the home since 1989 at the time the contract was signed, they needed to plead and prove abandonment, and they did not.
Can I, so in looking at the two requirements for establishing homestead, we see that it's overt acts of using the property as a homestead, which I think is what you were just pointing out. But that doesn't sound to me like evidence that it was her intent to claim the property as her homestead. So can you explain how the evidence proves that second element?
So for the second element, probably the best evidence I'd give you is just that during her own testimony, when she was consistently asked, about the home, is this your home? She said it was her home. She didn't come out and say, I have a clear intent to establish this as the homestead, as that term is legally found. And that type of evidence is, I think, would hardly ever be found. But there are some cases where there's, taxes and driver's licenses and so forth. And the evidence is unclear about any records showing that, but this court held in Hankins versus Harris and Solomon versus Lassay that no specific requirement or no specific writing is required, just merely showing that you are enjoying the home as your homestead, that there is no other home that you're claiming as your homestead is enough to meet at least the overt acts. But in terms of the intent, there's not a physical document or something from her where she says, I established this as my homestead. And this question really answers a lot here. We brought forth a cause of actions to invalidate the liens. And so if it is her homestead, and this court finds that it is their homestead, and the appellees have not proved undeniably clear proof that she abandoned the homestead, then those liens are invalid and entitles Ms. Rochelle to her attorney's fees as well. And we were prepared for this in the trial court below. We had even segregated out fees based on what went to the invalidated liens versus what went to breach of contract damages. The parties put forth their attorney's fees by agreement. And so this court could reverse and render on that point and segregate those fees out. The 14th Court of Appeals actually did that in Drake Interiors versus Thomas, where they sent it back to the trial court to segregate those fees out. But at the very least, this court could remand it to the court to do that as well. Also, on cross appeal, they bring their action for foreclosure. Naturally, if this court finds a homestead exemption, they would not be entitled to foreclosure as well. And I want to take a step back and talk about, not just digging into the case law, but really what's going on here in the argument that's put forth by the cross appellees. Their argument is not that it was never the homestead, and they don't put forth any evidence of any other homestead. They don't really dispute that at some point it was possibly her homestead. I mean, in terms of any other home. What they do dispute is abandonment. And they dispute that her intent to sell the home at some future time is proof of abandonment. But that is certainly not undeniably clear proof, and I don't think they have a single case where a future intent to sell the home is someone's homestead. For it to be my homestead, I don't have to prove that it's going to be my homestead forever.
Again, are we looking at the time frame for abandonment that's the same as the time frame that we look at the homestead at the time of the signing of the contract, not after?
That's my understanding, Your Honor, but admittedly, the case law to me is not clear that abandonment would only look at the time of the contract as the way that the homestead exemption was. But what is clear is that if they want to prove abandonment, they have to plead and prove it, and it has to be undeniably clear. And the appellees would like this court to believe that we have this monstrous burden to reach. But this court's case law is really in favor, and Texas case law is in favor of the homeowners, and for good reason. And if the appellees really believe that we want to sell the house, then they'll get their money eventually. But this is Miss Rochelle's home that she's lived in since 1989. She should get the chance to sell it, and it should not be sold in a quick fire sale in foreclosure. Texas is strong when it comes to the homestead, and naturally, Houston and the First Court of Appeals should protect homeowners when they're hit by 3 consecutive natural disasters. She got hit by the Memorial Day flood, Tax Day flood, and Harvey. And their argument is, well, you know, the home has gotten uninhabitable, they're having difficulty times, difficult moving back into it. But that argument's a little circular, and I'm scared that it would set up a disastrous precedent for contractors in the city of Houston to come into a home, not be able to get the home back under repair, and then strip Houstonians from their constitutional protections of the homestead. Additionally, the trial court below granted the directed verdict on statutory liens, and that was not in the final judgment. It's a little unclear why the court did not grant the directed verdict on the constitutional liens, but I think something that I'd really like to point this court to is that the mid-trial motion on page, I think it's 93 to 95, in discussing the mid-trial motion. The trial court, we're moving as defendants for our directed verdict on the invalid liens. The trial court was hesitant to grant our directed verdict on the liens because he said, I don't really see anything in plaintiff's petition that has brought a cause of action for foreclosure. I don't see a deck action for foreclosure. I don't see anything in this petition for foreclosure. Am I missing anything? He opened it up to both counsels. We said, no, Your Honor, we didn't miss anything. And when it came to plaintiff's counsel on page 95 of the second reporter, their counsel stayed silent. Said, we'll just rest on your denial. So they didn't bring their affirmative claim or really try an action for foreclosure to put it on the judge to really decide this question on the constitutional lien. He did grant our directed verdict on statutory liens. That's going to remove it out of the property records. Well, we at least ask this court to send it back to add that into the judgment to remove the statutory liens. But constitutional liens, and admittedly, I'm not positive that in this case it was recorded in the real property records, but typically the constitutional lien is not filed. So I believe that the court thought that I don't really have to make a decision on this constitutional lien because the plaintiff's not moving for foreclosure. And the homestead exemption on constitutional lien would really put me in a tough spot if I'm trying to make a decision on foreclosure, but they're not bringing an action for foreclosure. And if he was wrong, and maybe this court would find that way down there in the bottom of the pleading and such and other further relief as lien foreclosure, that's enough. At the very least, the trial court should get a chance to go through that investigation on homestead if this court finds that he didn't get that chance to. We asked this court to reverse the findings of the lower court because the liens were invalid. The appellees are not entitled to foreclosure. Thank you.
Thank you. Mr. Pitts?
May it please the court. This case is about the refusal of Ms. Rochelle for years to pay the Travis businesses that she had agreed under contracts. The jury heard extensive evidence that Mr. Travis and his businesses bent over backwards in 2015 and 2016 to help Ms. Rochelle with severe flood damage to a house she owns near the bayou here in Houston. The jury unanimously found Ms. Rochelle liable to the businesses for breach of contract, unanimously found the businesses had not breached any duty to Ms. Rochelle, and unanimously awarded as damages the exact amounts outstanding under the contracts. Each of these findings was supported by the evidence, and it was well within the jury's prerogative. Ms. Rochelle does not even contest the jury's liability findings on appeal. Unless the court has a different preference, I'm going to start with the liens because that's what we heard most about in the argument from my friend across the aisle. On a practical level, Your Honors, the lien issue determines if the proceeds of the sale of the house must be used to satisfy this judgment. And I want to be very clear, we absolutely contest that this was the homestead at the time the work was done and the time the contracts were executed. There's no conclusive proof in this record of a homestead. I think I heard earlier someone recite the elements that the Texas Supreme Court found in Zuria versus IPCO construction. It's a concurrence of overt acts and intent. There may be some evidence in this record of overt acts, but there is nothing, no evidence whatsoever of intent by Ms. Rochelle to claim this house as her homestead. The record is just empty of it. And the absence of evidence simply cannot be conclusive proof. And the problem would be that if the absence of evidence, which is what we have in this record, I did not hear my friend from the other side come up with any evidence of intent, then basically every residential property will always be a homestead if the person lived there for some time. And I want to make another point. I think Justice Countess talked about how a lot of the other cases deal with two properties. We don't even know if she owned another property in this case because she was never asked. She could not. The record's just empty of any evidence on that point. So I think the cases like IPCO and Zuria and the Hilliard case cited by the Supreme Court in Zuria, they all apply because we just don't have any evidence on this record to know one way or the other whether Ms. Rochelle intended this house to be her homestead. I want to make a few other points. If the homestead was not conclusively established, there was no discretion by the trial court to refuse to foreclose. That's the Crawford Services cases cited in the briefing, and that's not disputed on appeal. We also heard some suggestion that we didn't plead or prove foreclosure. On pages 12 and 15 of the clerk's record, we specifically asked for foreclosure in our petition, and the Texas Supreme Court in the Zuria case specifically held that simply proof of performance and existence of the debt was enough to foreclose. And in that case, all you had was a fraud finding by the jury. And the Texas Supreme Court said that the fraud finding encompassed those two findings that were sufficient to foreclose. Another thing I want to note is that it's black letter law in Texas that intent is a fact question uniquely within the realm of the trier of fact. That's been the law for many decades. In this record, all we have is a self-interested testimony of Ms. Rochelle that she lived in the house. That's it. There's nothing else. There's no documentary evidence of intent. There's no even testimony from Ms. Rochelle that this was her homestead or she intended it to be. She fundamentally failed to try her affirmative defense.
Mr. Pitts, what do you make of the evidence about her wanting to remain in the home during the remediation? I mean, that's arguably some evidence of intent.
I think that's an evidence of an overt act. I mean, she wanted to reside at the home for some time. Where was she going when she wasn't at the home? I have no idea. There's no evidence of that in the record. And I think it's okay there could be some evidence that's consistent with intent, but that doesn't mean it conclusively establishes intent, which is an issue that's almost always relegated to a trier of fact because it's only ever circumstantial evidence that really gets to intent. It's a very difficult thing to conclusively establish. It's hard to get a sense of it from the case law, like what would actually suffice, because factually those cases, as Justice Countess pointed out, are so different. I think the reason is that in most of the cases, you have the person testify that it's their homestead. Mm-hmm. And there's either evidence that controverts that or there's not. And that's sort of how the case law plays out. And that raises the question that why didn't she? It would have been 3 questions at trial to ask her, is this your homestead? Yes or no. Do you intend it to be your homestead? Yes or no. Why didn't she? And I frankly just don't have an answer. And that happened after they brought a motion for a directed verdict on the constitutional liens that was denied. So she knew that this issue was there and that the trial court may have thought there's a fact issue on it and properly did, but nonetheless chose not to even request its submission to the jury. And I'd also note that there's a long line of case law that the Zuria court cites, and it's the Hilliard case, and it goes even farther back. The courts cannot assume facts in support of a homestead. While the homestead defense is favored in Texas law, you can't just assume facts for it. And the reason being that in a case like this, where there's just no evidence of anything other than the person lived there, basically every residential property could become a homestead, even if there's no evidence of whether they owned other properties like this case or what's really going on.
Well, but here you do have evidence that she was living there, and the contract was signed there while she resided there. So I would say there is evidence that she was using it as her home. Is that right?
I agree, Your Honor. I think there's evidence she was using it as a place that she occupied, maybe her residence, and that's consistent with intent, but not conclusive proof of it. There is nothing in this record that conclusively shows her intent is to this house. And I want to...
What about the contract that has the language in it that talks about, here, I'll point you to it, pull it up really quick, that basically gives her the warnings about liens, and that if she doesn't perform, then it's possible she could lose her home. Is that not also evidence that your clients thought that that was her homestead because they thought they needed to put those warnings on there?
I think that would be
a contract signed at her home.
But I think that would be for any property, whether it's your second house or your fourth house or a commercial property. I mean, you can always have a lien, whether it's constitutional or statutory, and that lien can always be foreclosed under the Texas Property Code if it's properly attached to the property. And here, as the court knows, constitutional liens are self-executing and they attach automatically. And that brings me to another point about the timing. It's sort of a tricky issue on the timing because a constitutional lien will attach to the house if the homestead was not in place when the lien came into existence. For constitutional liens, that's when the contract's performed. So here that was 2015, 2016. So
Performed, not signed.
Well, I think the contract and the work was done in 2015 and 16. So I'm not sure it would make a difference here. So the liens will attach if there's no homestead at that time, and then a subsequent homestead could not affect the liens. They would remain in place. There's a lot of Texas Supreme Court law on that, and there's law from this court. And then I think I heard my friend from the other side agree that if it was later abandoned, they would then attach. And the 14th Court held that in the Drake case, and it cites a whole string site. So there's sort of 2 points you can look at. Here, I think the relevant time is when the contracts were signed and when the work was done, because there's no conclusive proof of a homestead at the time that was done. On abandonment, I don't think the court needs to reach abandonment because it's only an issue that's ever reached if there's conclusive proof of a homestead, which I think is just absent from this record. But if it had been otherwise, I think there is enough evidence of a fact issue on abandonment for it to go to jury. Of course, we never had a reason to submit it because from our perspective, the trial court had denied directed verdict on the homestead issue, and it wasn't submitted to the jury. So there's no reason for it to ever be submitted from our side. But it's undisputed that she left the house in 2017. She now lives in an apartment living community, and there's no evidence in the record of an intent to return the house. In fact, I think after Harvey, it hasn't been repaired since Harvey, from my understanding and from what the record showed. Unless the court has any more questions about the lien issues, we didn't talk a lot about the damages in the initial argument for the other side, so I'll just go through those very quickly. The jury had plenty of evidence for its awards of the exact amount of damages in this case. The standard submitted in the jury charge was fairly and reasonably compensate. That's the standard that was governed. There was no other standard requested or submitted to the jury. There is plenty of evidence in this case that the exact amounts invoiced would fairly and reasonably compensate. On tab 2 of our oral argument exhibits, it has a few of the critical excerpts here. On the top, you have the Travis Services contract. You can see that Ms. Rochelle specifically agreed to the amount of contract damages owed. That was followed by a contract that went line by line and itemized each price, and she initialed the price terms and then signed the contract. And in Texas, when you sign a contract, you owe the amount that was stated in the contract. There's evidence that Mr. Travis reduced the invoice, and the jury had every right to credit that, and that's due to the work that wasn't completed because of the later 2016 tax day flood. On the remediation contract, Mrs. Rochelle signed a work authorization that she would pay for it. Mr. Travis did all the work through his companies, and the jury had more than sufficient evidence to find that the invoice for the remediation was reasonable. Mr. Travis was designated as an expert. He oversaw the actual work, and he has hundreds of pages of testimony about the amount of work that went into this and how he reached the price, and he actually testified that the amount in the lien, which was the price, was reasonable. Unless the court has any questions on the damages, I'll get to the pre-judgment issue quickly.
Actually, can I, before,
Yep.
just because I don't, I mean, you've got a bit of time, but can you address a little bit about, I have some questions about whether about the lien and whether the file, whether you met the Article 16 requirements in terms of where it was, where the documents were executed. My understanding is that there's a requirement that they be executed at a specific place, and that doesn't appear that's what happened.
So, Your Honor, that is Article 16, Section 50 of the Constitution, which applies only to homesteads. So that section would apply only if there's a homestead on the house. Right. If there's conclusive proof of it. We don't dispute that the liens here don't meet, I think there's 5 criteria under Article 16, Section 50.
Okay.
And that's for the homestead, and it didn't meet those, but there's no conclusive evidence.
Okay, I just wanted to clarify where you stood on that.
Yeah.
Thank you.
On the prejudgment interest, very quickly, this court's binding precedent controls the issue. We have the Leisman v. Gordon case, and then the very recent Mulch Matters case, which is at tab 3 of our oral argument exhibits, which Chief Justice Adams wrote, which rejected the same exact argument made by Ms. Rochelle here about why the Travis businesses are not entitled to statutory prejudgment interest. You don't need to plead it, but we did plead it. You don't need to specifically plead it, that is, and we did specifically plead it. You don't need to submit it to the jury if it's a breach of contract claim. This was a breach of contract claim. The one argument in the brief I did want to spend just a minute or two on is the good faith provision. The good faith provision of the Prompt Pay Act does not toll prejudgment interest. There's nothing in the act that says that tolls prejudgment interest. It's really just a defense to the action in Section 28.205 of the Prompt Pay Act, which allows you to enforce the prompt payment, and it has no exceptions. So the good faith provision is just a carve out to that. And many courts around Texas, and the decisions are cited in our briefing, have concluded that the good faith provision doesn't toll anything.
I'm curious, kind of what happens, we talked about this with your learned colleague, what happens with the attorney's fees if we have a mixed result? Because we have cross appeals, like how would the court handle that according to you?
Yes, Your Honor. So as far as our attorney's fees, those were awarded and those would be done. If some issue was decided differently, I think they were talking about the statutory lien issue. That's discretionary with the trial court. I think I don't have the property code provision in front of me, but I think the standard is in just discretion or something, whether the trial court issue that. And they asked for that in the trial court, and the trial court denied it. So it's really a question of, did it abuse its discretion in not awarding those? So, and it didn't for a couple reasons. First, we never even asserted statutory liens in this litigation anywhere. If you look at the liens themselves, they only reference the Texas Constitution. If you look at our pleadings, we never reference the Chapter 53 provisions for perfecting a statutory lien. We only ever talk about the constitutional liens because that's what we've always asserted that we have. So I don't think they would get fees for invalidating a claim that we never even saw it, which is why it wasn't really disputed at trial either, because I think trial counsel for the Travis businesses basically said we're only asserting constitutional liens, and then the trial court granted directed verdict as to the statutory liens, even though it just narrowed the issue basically. And even if it was subject to discretion, we had a unanimous jury that decided against Ms. Rochelle in every issue in this case. So it was certainly within the trial court's discretion to not award fees, first of all for a claim that was a statutory lien claim that was never argued or submitted, and when the jury unanimously found against her on every issue. So I think so your broad question of what do we do, I think there's nothing that can or should be done about fees. Okay. The trial court did abuse its discretion in denying them one way or the other. As far as my notes all jumbled. As far as relief, the Travis businesses were asked the court affirm the judgment is modified to first amend the prejudgment interest rate to the 18% prejudgment rate we're entitled to into the proper timing. The final judgment below shorted it by a couple months for reasons I'm not sure of. It should have ran to the time of judgment, but it didn't. And then also authorize foreclosure of the property in the language that was requested to the trial court. There's one case I wanted to point the court to before I close on the homestead, and that's Robertson versus Homeowners Loan Corp., 147 Southwest 2nd, 949. It's a Dallas case, 1941. And that case basically stands for the proposition that just even living on the property with your family does not suffice to show intent of homestead. And that's the only case I could find that was directly about did living with a family on the property suffice or not.
Thank you.
Unless the court has any other questions, I'll yield back the rest of my time.
Okay, thank you.
Thank you.
We have your argument.
May it please the court. As you can probably guess, I'm going to go back to the homestead exemption issues and as well as the liens. My friend on the other side said there was no intent to establish it as a homestead, and I'm not really sure what type of proof he wants. This court has been explicitly clear that no specific writing is required. He asked, why didn't their trial counsel ask Ms. Rochelle, did you have an intent to establish this as your homestead? Well, if I would have been on the other side, I would have objected to speculation because Ms. Rochelle is not a lawyer. Normal people don't talk the way that we do as lawyers. The evidence of the intent and the overuse of homestead typically come in the form of, I raised my family here. I've lived here since 1989. I raised my sister's children in this home.
What do you make of that Dallas case Mr. Pitt cited? Are you familiar with that? Saying that living there is not enough, using it as a residence is not enough.
I believe he cited to Zerillo.
No, it was a 1946
1941.
case or something.
He just mentioned it at the end of his argument.
Oh, I'm sorry. I'm not familiar with that case. We certainly would love the chance to submit some supplemental briefing on that. I think that the case likely didn't go the way of the homeowner because there was inconsistent use of the home, or maybe the homestead wasn't really pled. They do cite a case of Zerillo for the proposition that just living in there inadvertently doesn't establish the homestead. Zerillo is very different from this case. In Zerillo, the homeowner never even pled homestead, let alone really argued at a trial. It was a post hoc attempt. But throughout this trial, we've argued for the homestead exemption. And we showed that from 1989 through all the way that the contract was signed, she had lived there consistently. My friends on the other side also said that they don't really know, where she was living at the time the repairs were going. The record does say she was living in her son's apartment temporarily. And I think when this court looks at a lot of the case law on homestead, you'll see there's cases where someone has moved out of the house and is temporarily renting the home. There's cases where the home was, later sold in a foreclosure, in a collateral proceeding, it was attacked. So just because you move from one residence to a different one temporarily, it doesn't mean that you lose that homestead status. That's this court's own words in Hankins versus Harris and Solomon versus Lassay. And that's consistent across all Texas case law. Everyone's in agreement that you construe it in favor of the homestead. Once it's clearly established as a homestead, it has to be undeniably clear that they have abandoned the homestead. And it's not undeniably clear in this case. All it is undeniably clear is that Miss Rochelle, as an elderly woman, has suffered through 3 natural disasters that have displaced her from a home that she raised her children and lived in since 1989. That cannot be the precedent that this court, especially in Houston, sets for Houstonians who deal with floods, who deal with Hurricane Harvey, and so forth. I've got friends right now who are in hotels because their power went out this weekend. Does that mean they're stripped of their homestead status just because they're out of the house shortly? That can't be the precedent this set. This court should reverse because the liens were invalid. And sorry, I just have to mention one more thing. The Chapter 53 liens, in the first few pages of the clerk's record, you'll see a lien affidavit where they filed a Chapter 53 lien. There's a an affidavit that says we're asserting a constitutional lien. There's another one that says Chapter 53 lien. I'll be honest, I didn't go check the property records, but I'm almost positive they filed it. It's something that we fought consistently, asked the court to issue a judgment to remove the 53 liens. He granted a directed verdict on that issue. You'll see that they did fight us quite a bit on the statutory liens and the constitutional liens numerous times. So Chapter 53 liens is certainly an issue, and Justice Lando, we would ask that this court go back and look at remand to the lower court for the attorney fees portion for these liens to invalidate these liens. And it's for these reasons this court should reverse.
Thank you. Thank you to both sides for your briefing and argument. Your case is submitted.